Okay, today I want to just take a look at some happenings, legal happenings during the week in the world of law. The first case I want to look at is a trial of 4 men accused of raping a woman in Dublin, or at her Dublin home. It has collapsed. The background to this case is the woman was in touch with a chap who she gave him to understand that if he came over to her house that sex would be a prospect, or would be a likelihood. That's the evidence anyway that he gave. Her mother, I think, and her sister were to be away on that particular evening, and the fellow went over, but he went over with 3 other men. So they moved then at some point in the evening from the lower part of the house, from the ground floor of the house to the first floor. She went to the toilet, apparently, came out, and the boys started pulled down her trousers and started slapping her rear end, and basically she claims that she was raped and sexually assaulted and orally raped and so on. So the trial started there this week. It was going on for 3 days. She was giving evidence then during the week, and she was being cross-examined. She became upset in the witness box and asked for permission to break. So then it transpired that the judge was advised later on then by one of the prosecuting lawyers that the woman was undergoing psychiatric treatment for an ongoing issue with mental health, and the prosecutors were basically liaising with the woman's doctor to see if she was going to be fit to give evidence in the trial. They indicated then on Tuesday that due to medical advice that the state wished to apply to the court for permission for the woman to give evidence by video link. And the judge said no. So the state was not successful in this application. The woman apparently is in a mental hospital, mental institution, and the case therefore has collapsed. So the judge told the jury, you've been here for 3 weeks, and unfortunately the trial did not come to a natural conclusion, and the woman in question, the woman whose allegations brought her about this prosecution, she will retain anonymity for life, but also the 4 individuals who were accused, young men 24, 25 years of age, who were accused of rape and sexually assaulting her, they will retain anonymity for life as well. So that is the first case I want to discuss, or that I just thought was interesting, insofar as that's what can happen with these cases. They're not cut and dried, and no matter what the evidence is, it can be a situation where cases simply collapse, and the men in question are entitled to the presumption of innocence and so on, no matter what the evidence was. There was another interesting case there involving a personal injury claim. This was an award of €167,000 over an assault at a barbecue in Cavan. The award included €20,000 to cover the replacement of 8 teeth. And this involved a shocking assault by, I think, a Polish gentleman on a Czech national Polish national on a Czech national at a barbecue at a house in Ballygemsduff, County Cavan in 2017. The interesting thing about this case, as I see it, is that the victim, who was perfectly entitled to bring the claim against the individual who assaulted him, has been awarded €167,000, has had to go to the High Court to get his damages assessed, and the problem is, how is he going to get paid? Because the fella who inflicted the injuries on him, showed up in court the other day and basically said that he has no money. So that will be a difficulty for the victim. It'll be a difficulty for the victim's legal team, and basically the chap who did the assaulting, the person who was successfully sued for the personal injury claim for the 167,000. He's a father of 3 from Poland. He was in court And he asked the judge to consider that he would not be able to pay because of his financial situation. And that obviously can happen very, very easily where a person simply doesn't have the money. So you can sue a company or sue an individual, and you can find yourself having very limited, very Pyrrhic victory insofar as you may well win the judgment, you may well win the case, but enforcing your judgment and giving effect to it could be a completely different situation. It's also an interesting case there about the appointment of a receiver to a house where a couple, the owners of a Malahide property, were in difficulty with their mortgage. A receiver was appointed, and according to the judge, the couple were involved in egregious intimidation of the tenants who cooperated with the receiver. The tenants were forced out of their home with genuine fears for their safety. And the judge found that there was a campaign of harassment and intimidation visited upon the occupants of the property by a man apparently acting on behalf of one of the former owners. She granted orders sought by the receiver, Ken Fennell, to secure possession of the house in Malahide in Dublin that had been owned by Brian and Irene Riley. The judge's orders, which continue until the full court case is resolved, restrain the couple from taking possession of the property and interfering with the receivership. And she said that the pair, either personally or through their agents, have harassed, intimidated and threatened tenants and received rental income that was not used to discharge the loan. We're told there that the property was purchased in 1990, remortgaged in 2007 to part finance the purchase of an apartment in Malahide where they now reside. The judge said full payments had not been made since 2009, and the loan was sold to Promontoria Oyster DAC, which in September 2017 demanded immediate repayment of $845,700. 2 months later then, it appointed Mr. Fennell as receiver of the house, which was occupied until the Residential Tenancies Board ordered the tenants to leave. Mr. Fennell took possession of the property in late 2018. It was reoccupied in 2019. The new tenants, including a woman and a young child, informed Mr. Fennell's team that they had a 1-year lease from Mr. Riley. So the tenant, as far as they were concerned, were there lawfully, and they had entered into a tenancy agreement with one of the owners. They attempted to cooperate with Mr. Fennell, the receiver, and paid rent directly to his agents, because Mr. Fennell, the receiver, or his agents would have gone out and said, look, I'm a receiver, lawfully appointed, and you must pay the rent to me. The tenant did that, but then was, according to the judge, subject to a sustained campaign of harassment and intimidation that appears to have been conducted at the behest of Mr. Riley. That's a sad situation there. Obviously, tenants being forced out of the house in fear for their safety, borrowers losing the house, or at least at risk of losing the house, and obviously the receiver then obviously having his own difficulties with doing his job. The judge was satisfied that the receiver had established a strong, arguable case that he was validly appointed as receiver and that he is exercising powers validly conferred on him. She was satisfied damages would be an adequate remedy for the Rileys if they ended up being successful in the wider action. Therefore, she granted possession of the house to the receiver. Another case there involved a child suing through the parents, a 7-year-old child suing through parents for a personal injury claim suffered on an Aer Lingus flight, where a cup of tea is said to a girl scalded by boiling water on Aer Lingus flight settled her case for $23,000. She was 7. She was travelling with her mother on a flight from Shannon to Lanzarote in 2019. It's claimed that the cup of tea was ordered and a cup of boiling water was being put on a tray when the incident occurred. The girl suffered a burn injury to her right arm. So she has claimed successfully and has been awarded $23,000 for that injury, and the judge approved the settlement. When a settlement involves a young person, a minor, a court must approve it. There's also a story there about an activist, Stephen Bedford. He was squatting at a Pimlico pub. He was charged with criminal trespass and breach of peace. He was greeted with applause by supporters after Dublin 8 eviction featured prominently on social media. He claims that he was providing homeless services while squatting at a vacant pub in Dublin. He's been released on bail after being prosecuted with a criminal trespass offence. He's accused of trespassing with intent to interfere with property or commit an offence at Pimlico Tavern, a breach of the peace, and later giving a false name at a Garda station. Videos and images of the arrest were posted on social media. They featured a man on a balcony remonstrating with the crowd below as a flag flew from the roof of the building. At the start of the district court hearing, he was greeted with applause by supporters in the public gallery, whom the judge ordered to leave the courtroom. So counsel said that his client had issues with that, the objection, just in relation to bail. The Gardaí had no objection to bail, subject to a condition that he stay out of Pimlico. Counsel said his client had issues with that because Mr. Bedford had been squatting and offering services to homeless people in that property. He then faced a bail objection. Following a recess, the defence said the accused would sign the bail bond with the condition imposed. The judge released Mr. Bedford, a self-employed audiovisual technician who has yet to enter a plea. Finally, there's another one of those sad cases where a person is unhappy with the outcome of a probate matter. The Supreme Court has halted a woman's 7-year battle over her father's estate. The Galway woman claimed that she did not get full share of her estate after her father died in 1987. This is a 7-year legal battle by a woman against two older siblings over allegedly not getting a full quarter share of their father's €308,000 estate after his death 36 years ago, has been halted by the Supreme Court. So to put it in context, 308,000, if you were getting a quarter of that, it's not a huge amount of money. Obviously it's a significant amount of money, but it may pale into comparison when you consider the costs involved in going to the High Court, going to the Court of Appeal and going to the Supreme Court. The lady in question, she was aged 17 and the youngest of 4 children when he died without leaving a will. A panel of Supreme Court judges, 3 judges, said she had not met the criteria for a further appeal after a Court of Appeal last year dismissed her appeal over the High Court's rejection of her case. So the High Court rejected her case, the Court of Appeal rejected her case, and then she wanted to go to the Supreme Court. The Supreme Court found that the facts did not support the proposed grounds of appeal, and no matter of general public importance had been raised. They said the interests of justice are not served by any further hearings in this litigation. That conclusion, they added, was further borne out by the fact that the proceedings related to the estate of a man who died in 1987, and that Miss Cuniff had reached the age of majority in 1988, where distributions had been made and accepted in the administration of the estate up to 2004. She claimed she hadn't received her full entitlement. The net value of the estate was £243,000. Michael took over the running of the farm, assisted by his brother, and Martina then, she was the eldest sibling, she became the administrator of the estate. She initiated High Court proceedings against Martina and Michael, claiming breach of duty, negligent misstatement and or misrepresentation about the estate in 2016. So that is another sad case, and one further important point here is that I think in dismissing her appeal against the High Court findings, the Court of Appeal warned litigants against using unqualified, unregulated and uninsured legal consultants holding themselves out as being professional Mackenzie friends. These individuals, according to the judge, all too often give rise to false hopes, potentially expose litigants to liability for the opposing party's costs, and, at a very minimum, waste money for those they purport to represent, the court said. So that's a sad case. Supreme Court has prevented the woman from pursuing this matter any further, and she's going to have to simply accept the decision of the High Court, accept the decision of the Court of Appeal, and forget about it, quite frankly. Hope you find this brief roundup useful of the last week or so in the legal world, as it were, in Ireland. Today is Friday the 20th of October 2023. If you're watching this on YouTube, you may be interested in subscribing to my channel, and you might hit the old like button down below. And if you're interested in a sort of a roundup every week, maybe at the weekend, Friday, Saturday, Sunday, let me know in the comments down below. Drop a comment. And if you're listening to this on iTunes or on Spotify, on my podcast, the Irish Law and Small Business Podcast, you can leave a comment there on Spotify as well, or you can simply subscribe to my podcast, the Irish Law and Small Business Podcast. Thanks a lot.